SJC-13622, Jacqueline Johnson versus Energy Facilities Siting Board.
Hi, is it Attorney Senni?
Yes.
Okay. It's your turn.
May it please the court, my name is Christopher Senni. I represent the appellant in this matter, Jacqueline Johnson, who owns property near the site where a substation is proposed. Ms. Johnson is in the courtroom today. As you know, this is a matter that comes up from the Energy Facility Siting Board. Appeals from that board come directly here. At the heart of this issue is a sound study, which is somewhat typical in EFSB decisions. In fact, there are two sound studies in the record, and that's because the engineers who prepared the sound study in the case at bar relied on one that they had done 4 years earlier for another substation to be built in Barnstable to take electricity from the offshore wind turbines. And it is the difference between these two sound studies that caused me to take this case. And the basic difference is that a guide was used, the EEI guide, Edison Electrical Institute guide, which is a reference guide. It's 40 years old today. It was 38 years old when it was used in this matter. And that's not the gold standard for sound studies. Typically, we want to have sound power data entered into a model that is confirmed by the manufacturers of the equipment that will generate the sound. And in 2019, the board accepted the EEI noise guide as the starting point for an acoustical model and approved that project, and no one appealed it. The same engineering firm used the same guide in this case, but then made further reductions from the sound powers that one would arrive at by using the formulas in the guide in order to make the model show compliance with the DEP noise policy. And when I saw that, I thought something was wrong with this sound study, because just like getting ambient readings on the back end of an analysis, which you are comparing the projected sounds to see if this new facility will increase the ambient by 10 decibels or more, you need reliable information on the front end, which would be the sound power levels that get entered into the model. There are 34 pieces of equipment that will go into this substation that generate noise. They are covered in 2 tables. And actually, these further adjustments in sound power, which the siting board called subjective noise reduction adjustments, apply to 28 of them. So 82%.
Can I focus? I'd like to focus on something that I want to hear your response, because my questions are going to really be directed at your opponents for the most part. You're getting into a technical level of sort of process that I understand, but what I'm focused on in particular is findings 42 and really 42. I guess actually maybe it's 41, 42. The siting board states that it shares Ms. Johnson's skepticism regarding the company's self-described aggressive assumptions. While the siting board does not prescribe specific types of evidence, we do ensure the results of such modeling are reasonable and enforceable. The language I'm focused on is this. The siting board stated, while there is reason to be skeptical of such adjustments, the company may in fact be able to secure equipment that meets these specifications and achieves the modeled noise levels at nearby receptor. That is an odd formulation to me. I guess the first question is, if 10 dB is the maximum, I understand if they wrote the following: there's substantial evidence to support all of the science you're talking about here that it will achieve the 10 dB. But they don't say that. They say it may, and then they're going to take a second look. Do you win because of that? Do we have to remand this to require them to clarify that they believe it will work? That it's not enough to say it may and build a big building. Is that enough for you to win? Because I'm going to pursue that with them, because that's what, I don't understand all this science, but we have a lot of deference on science if the siting board actually makes a finding that says this will do this. We don't owe deference if the siting board says, well, I don't know, maybe it will, maybe it won't, and we'll take another look later. You win?
Well, I don't know, Your Honor, and only this court will decide that, but
Well, I'm asking, should you win? I know you don't know if you're going to win.
I briefed that that's pretty weak to say, well, maybe they will be able to get manufacturers who will be able to make uniquely quieter equipment, and therefore the model will prove to have been true. And the way I view what you're reading is if they may be able to succeed, and there's really no evidence from manufacturers in the record, they also may not be able to.
And if they don't, prior to the build, don't they, then they won't be able to build this thing, right? Because the board said, we don't know. These are aggressive assumptions. Epsilon is saying that they can do this, but these are, everybody thinks it's aggressive, and this is the maximum that we can do on sound levels as they responded to the board. We can't do more. The board says, I don't know, but before you start building, come back and show me that you've obtained the equipment from the manufacturers that achieves these sound levels, which I think was 8 dB.
See,
Right?
8 dB.
So why is that not good
Can I
enough?
ask, is that actually right, though? Is that what they say? They don't say that. They say you build it, and then, is that your understanding of what it says, or is it say you can build it?
They do both, right?
They
They
do
say, come to me before you build it with the, manufacturer specs, and then if you achieve 8 dB, great, then build it, and then after 180 days of operation, do it again.
Yes, they have both. In this condition S, which is at the heart of the matter, the siting board requires both. And the board says to get earlier visibility, meaning before you spend all the money to build it, when these sound power profiles, which is what it says, noise profiles still have to come into us, are available from the manufacturers, come back with a compliance filing to satisfy us that the manufacturers really can do this.
And why, and so my question to you was, why isn't that good enough? Right? The board's saying, I don't know, these are aggressive, show me.
Yeah. The regulations that control this process and your judicial review say that the decision has to be supported by substantial evidence of record in the proceeding. And the compliance filing is coming after the proceeding. It's not here today. We don't know what it's going to say. And a final decision was issued based on what the board is skeptical of.
So your position is that this substation shall be built even if they come back pre-build and they can't meet the ADB that they've said that they could?
Yes, and it comes from the very language of the condition that was intended to fix the problem here, or the lack of substantial evidence before the board. The language is do two things with this compliance filing. Give us the noise profiles that are missing, and give us your plan to further mitigate sound as a result. And so this sets the scope.
Well, it's not just to further mitigate sound. I thought it was further mitigate sound. If you can't get the manufacturers to give you the equipment under the aggressive standards, right, then we're not going to say no substation, but you're going to have to build a wall and close the transformer, I don't know, do whatever you need to do in order to meet what you've said you can meet, which is less than 10 dB.
Yes, that's correct. My concern is that there is no set of mitigation measures that can accomplish it.
I'm confused, though. Where in the opinion is this? I understand there's the decision, and then there's the condition S or whatever it's called after the thing is built. Where in the opinion is this compliance? What does it say? Because I want to make sure that I understand that interim step and how that works. Where in the opinion is that? Because
the compliance filing is in Appendix 1.
yeah, I've got the siting board decision. I really want to read. I'd like you to read us the language.
Yes.
That,
So there is a series of appendix volumes. Volume 1, page 244.
Volume 1, 244. Okay.
I can read it, but
Yeah,
if you're
if you-
searching for it, I'll wait.
No, read it.
Okay, in addition, to gain earlier visibility of the steps being taken by the company to achieve this result, the siting board further directs the company to provide a pre-construction compliance filing documenting A, the noise profiles of the substation equipment types listed in exhibits such and such, when the relevant information from the equipment supplier is made available to Park City Wind, and B, any additional noise mitigation measures such as additional or taller sound walls that the company intends to take as a result.
And is there a follow-up sentence or two that says, and they can't build unless this decreases this below 10? Because that's the key sentence. I understand submitting it, but do they get to build before they've made a finding that it's below 10 or not? I just don't know.
I actually went through the exercise, Your Honor, myself, because there is no following sentence that says that, of rewriting conditions.
When I read the S discussion, it says they have to mitigate it, but mitigation doesn't necessarily, it doesn't say we will shut down the building if it doesn't get to below 10. I'm just trying to understand, because we defer to these people tremendously if they are making findings that this is below 10.
Yes.
And we don't do what you do, which is say, well, I don't like their science. We're just not very good at that.
Yeah.
But if they don't reserve the right to prevent this from being built until they're established that it's below 10, then I understand your point.
Yes. And condition S would have been lawful if it had said two things. One, when the compliance filing comes in, there shall be a public hearing as a continuation of this hearing, and all parties shall have a chance to cross-examine that evidence. And number two, at that time, the board should have the full array of its normal powers to deny the certificate.
So what happens in the second stage then? This compliance, so now at phase 2, they're going to submit their actual plans, and does there have to be a finding that it's below 10? Do you get any participation in that? How does that work?
Well, a compliance filing is a unilaterally filed document. There is no guarantee that that will be the subject of any public discussion. If you look at the transcript where this is...
But do they have to make a finding? Is there something in here that gives me a comfort that the siting board, who does very sophisticated legal work,
I think
has to
counsel...
find that
Yeah,
it...
I don't see it. The reason I'm here is that I am concerned that if the compliance filing contains evidence of which the board is equally skeptical, I think because it didn't warn parties and reserve to itself the right to deny the certificate, it has no choice. It has no authority to revise its decision, and all we will be left with is trying more and more versions of mitigation. But in my opinion, there's testimony that at least the perimeter wall separating my client's property from the substation is at the point of diminishing returns. And they've testified that the kind of wall, what it's made of, and the heights involved.
But again, if they found substantial evidence to say it would mitigate it, you're out of luck. I just can't tell if they found it or reserved the right to make that finding, you know?
My client has only wanted to have the opportunity in a public hearing format to look at the real evidence. And I think the evidence that was presented is too weak to meet the substantial evidence of record in the proceeding standard. And my concern is that my client won't be given that due process right to be in a hearing room and be able to question those who are offering this evidence that's coming in later. Unless there are further questions, I'll yield the podium.
Thank you. Attorney Hewer.
Chief Justice Bud, may it please the court, Tad Hewer on behalf of Park City Wind. As a logistical note, Mr. Hitt and I have divided our time. We're both prepared to answer questions on any topic, although technical questions about evidence may be better directed towards me, and questions about the board's statutory authority may be better directed toward him. Ms. Johnson asks this court to do something it has never done before, which is to second guess and reverse the board's conclusions on the sufficiency and credibility of technical scientific expert evidence. And I want to emphasize 3 points.
But the
I think
board
Justice
didn't
Ginsburg
actually,
stop me.
Yeah.
the board didn't actually make a finding on the technology. It said, we don't know, seems aggressive.
2 things. One, it's Epsilon, the engineers here, who said that they thought these were aggressive assumptions, but they knew from their expertise that they were reasonable ones to make.
Yeah, and it would be a different story if the board said, you know, Epsilon, they're really qualified. They know what they're doing, and so we believe them. And
I believe
therefore, we're going to find that the project has 8 dBs at Ms. Johnson's house.
I believe they did. If you look at the end, they say, we have indeed agreed that if these conditions are met, the project will mitigate. And here's how we know that the conditions are going to be
the conditions, the conditions, the parameters were set in order to meet the 8 dB outcome. And what the board says is, we don't know if you can.
I would beg to differ. So what the board says in its decision is, we are skeptical of the ability for the sound power numbers for the equipment to be the reductions that you say they are. They are not saying that 8 decibels at the property line is not the appropriate number, and they also say there's an absolute obligation to meet that 8 decibel number, regardless of how you get there.
Where?
What the
Where do they
board-
say that? Because
The absolute obligation?
because I want you to give us, because again, I agree with you. If they made a finding that it is under 10 dB, that we conclude based on all this evidence that, you know, there's reason to believe that it will be under 10, I'm with you. What I'm not with you on is it may work, it may not. File some other stuff later, that may work, that may not. And then build it, and if it doesn't work, mitigate it. But mitigating, I know a lot about mitigation, that isn't necessarily getting it to below 10. I need you to find, and I would encourage you to be specific. If you can find in the opinion language that proves that, because I'm very troubled by the language I read.
Right. So I believe it's page 244, volume 1 of the appendix. Halfway down, it says, in addition, the citing board notes that the findings in this decision are based upon the record in this case. A project proponent has an absolute obligation to construct and operate its facility in conformance with all aspects of its proposal as presented to the citing board. And the proposal made by Park City Wind was that at the property line of Ms. Johnson, it will be no greater than 8 decibels. That is the promise that they made. That's the thing that we would be held to. We cannot construct and move forward. Not only can we not construct, we can't even get the authorization to construct until we have provided a compliance filing. And I'd say the distinction between a compliance filing and additional evidence is the decision here's already been made. The citing board has said 8 decibels, and we think it's 8 decibels is appropriate because of your modeling, which is how the citing board routinely and always determines what a noise profile will look at. And they say, that's perfectly fine as long as you can do a pre-construction filing before you even get in the ground. And then once you've met that obligation, you've got to do a post-construction filing to prove it actually works.
May I ask you a question? Because
to my mind, part of this is maybe a drafting issue. If what I hear you saying is that the company understands what the board to have done is to require a no greater noise increase at Ms. Johnson's property line than 8 dB. You understand that your construction of the project depends upon your proving that.
Yes, I would also say,
And-
as a practical level, our financing probably depends on us proving that.
Okay, so, and we're going to take, and now, unfortunately, it's not quite as clearly written in the siting board's decision. But if there is agreement that that is actually what the siting board meant, that in other words, construction depends upon your meeting this representation that was made, and that you establish that before construction, that that's actually what's meant by condition S. Is there a way that, what do we do? Do we remand for clarification so that that's rock solid? Can we do that? Or, because I'm looking at the language on page 170, where it looks to me that that what the board is saying is that you're going to have to prove that you actually meet that within 180 days after operation, right?
Undeniably.
Actual compliance.
Absolutely.
But then the second sentence, when it comes to the pre-construction compliance report, it doesn't actually repeat the 8 dB standard. It says, you must give us a pre-construction compliance filing document that the noise profiles on the equipments listed in these tables are going to be made available to you from the manufacturers. In other words, it seems to be more like a requirement that you have to prove that you can get what you've listed from manufacturers. But it doesn't repeat what I assume is really the relevant thing for Ms. Johnson, which is that what comes across her property line is no more than 8 dB.
All right, so I'd make 2 points. One, I think we need to continue reading that sentence there.
Okay,
Right, so we're in the middle of 170.
yeah.
And it says, to gain earlier visibility, et cetera, we've read that. And it says, B, any additional noise mitigation measures, such as additional or taller sound walls, that the company intends to take as a result.
I
And those words are critical, because if you've met the 8 dB with simply your sound power levels of your equipment, then there is no additional noise mitigation measures
But
that
it
need to be
doesn't
taken.
actually reference the 8 dB. That's my only point.
But again, it's
And nor does
because,
244, the sentence you read us there, also doesn't reference the 8 dB. It just says if you make changes in the project, you got to tell us about it. And the first sentence is you got to build it as with all aspects of its proposal. But the proposal, the proposal is the construction, not necessarily the result of the construction. I don't know.
no, again, I'd go back to the words absolute obligation. You have to read this, not just page 244, but this is an 100 and some odd page decision with several thousand pages of application. That application says, and we can put it into the record, that 8 decibels at the property line, it's in the record, it's not in the appendix. 8 decibels at the property line is what we are going to build to, and that's what we're instructed by the siting board to do. We have an absolute obligation. We can't get out of it. It's not, maybe you can come in at 10 and we'll talk about it. Maybe you're at 6.5 and that's okay. They said 8, and we have to meet 8. I'd make one other point briefly.
You could be less.
Certainly, we could be less, but I think that's another key point here.
But it's the or else. I understand you have to meet it, but they're skeptical that you can do it. And then they have this 3 stages of evaluating it, including the whole post-construction indicates they're not comfortable that you're going to achieve it at either the first, that your proposal achieves it, the compliance documents achieves it, or, so we've got this third mitigation. It just, shouldn't we require them to be, that if the siting board has said it, why not make them do it?
First of all, I'd say that as a practical matter, they are going to do it. That's what they, as Justice Wellhogen said, that's our understanding of what this requires, that we have to meet 8 decibels at the pre-construction filing and the post-construction filing. I don't want to get to a point where we're saying that modeling isn't substantial evidence. Modeling is how substantial evidence is found.
The science, it's how they articulate what they've found. We understand we use the words great deference, we go on and on about the deference we owe, but we require them to say it. We don't sort of let them dance around about their skepticism and things like that. And we'll ask him directly, but
I'd make 2 points on this. One, I just want to bring the court back to what it said in the Andover case about 20 years ago, where the exact same question was raised. And the court said, the interveners challenged the proposed sound mitigation measures as lacking in final design specifications. As with air emissions, which were also at issue in that case, it makes little sense to require a developer to finalize the details of sound mitigation measures until it learns what additional measures the department might require. This court has already recognized that these are complex projects and that there is some level of determination when you go forward as to exactly how you're going to meet the standard that the board has set. Here, we have a situation where they have said there are two ways, and you see this in the expert testimony, to determine where you're going to get your sound level to. One is making the equipment quieter, and the other is on-site mitigations, walls or blankets or whatever else you're going to mitigate external to the power levels of the equipment. All the board is saying when it is saying we are skeptical, and we can go back to that language, is the board says we are skeptical, shares the skepticism regarding the company's self-described aggressive assumptions regarding the noise profiles of its intended substation equipment. It is saying we're not sure you can meet it with the substation equipment, but we're not saying we don't think you can meet it. You just may need to do more mitigation. And that's exactly what they say on the next page when they say, right, your pre-compliance filing, show us your sound power levels, but if they're coming in too high, you better be showing us some more mitigation. That's exactly what this condition says, and that's exactly what this proceeding says.
Is table 7.3 all of the equipment, or is there missing from that requirement table 7.4?
Table 7.4 was an errata. The decision has been revised by the siding board to incorporate 7.4. It was always intended that they were both done.
Okay.
So all the equipment at the site is subject to these requirements. I think the analogy I might give is you have a patient who goes to a doctor and says, I want to lose 10 pounds, but I only want to do it through exercise because I don't want to give up the ice cream, right? The doctor says, there is substantial evidence that you're going to be able to lose 10 pounds, but I'm skeptical that exercise alone is going to do it. But exercise and diet, you can get to that 10 pounds. That's essentially what the siding board is saying here. We're not sure you're going to get to it with your aggressive presumptions on the sound, power, noise levels of the equipment, but we're not saying you can't get to 8. And regardless, we're holding you to 8. If there are no further questions, I would defer to the Attorney General.
Okay. Attorney Hitt.
May it please the court, Assistant Attorney General John Hitt for the citing board in this case. I'm going to kind of restructure my argument to try and jump right to answering some of your questions that were just proposed or posed by you all. In particular, so the citing board does go through and discuss and find substantial evidence to support the noise modeling and what ultimately becomes its discussion of Condition S. If you look in the citing board's decision at pages 153 to 154, I'm referring to a page number which is actually on the upper right-hand corner of the citing board decision, because the citing board appears in different addendums and appendixes. There, the citing board, this is where the skepticism language is and where they kind of get into the heart of discussing what they ultimately convert into the language in Condition S. The skepticism that the board expresses is simply on the ability to mitigate the noise. So whether once the equipment is built, if it's going to have all of the sound baffles and things built into the particular piece of equipment. The use of the word skepticism really just refers to that narrow issue.
Why don't I find, read it to us and tell us why, because, and I thought, I was reading, is 171 the same as the other page where we get these two clauses? Because
Yeah, it's 169.
yeah.
Yes.
So tell us why that means that they're not skeptical. I'm at a loss that they think the mitigation won't work. They're skeptical on the mitigation, but they're not skeptical that this is going to produce the 10 dB.
So, Your Honor, I would start on the second page of their discussion at the very bottom where they say, in addition, the siting board notes that the record demonstrates that several aspects of the CAD-A sound model used to assess noise impacts at or near receptors are likely to be conservative, and actual noise impacts may be less than modeled. So on all the evidence, obviously this is not, it's not like we're going to Home Depot and taking something off the shelf to be the basis of what is going to be in evidence before the siting board. Here, they're relying on this modeling, and in terms of the evidence that was submitted at the siting board hearing relating to the modeling, there was substantial evidence to show that they would meet their 8 decibel. Yes, Your Honor.
As I understand the crux of Ms. Johnson's argument as it was presented here today, is that the true objection is that there'll never be a procedure by which the pre-construction report or the post-construction report can be tested, and particularly the pre-construction report, so that when the company comes back and says, oh, here's, whatever, we have more modeling, we have quotes from manufacturers, et cetera, there's never going to be an evidentiary process by which to test the accuracy of those things. That's what I understood to be the crux of the argument today, was that the plaintiff could essentially live with condition S, understanding it as it's been explained today to actually require 8 dB at her property line, provided there's an evidentiary process for testing it. What do you say about that? Because that sort of makes sense to me, that where there's an expressed skepticism about the evidence the company presented at this stage, the board has expressed that skepticism and has asked for a report to try to allay that for the future, because they want to make sure that the company's going to be able to meet this standard. Why shouldn't there be some kind of process built in, similar to what occurred before the siting board decision, as to this one open piece?
Well, I think here, Your Honor, the board was trying to do that and do that balancing trick that it has to do, where here it is the agency that has to go first in the entire permitting process, first among.
But doesn't it at some point actually have to make a decision that whether that 8 dB can be or has been met?
Yes, Your Honor. And
so how will it do that once these reports are filed? Just accept the reports? Those reports will just be taken at face value?
Well, Your Honor, they did make a decision that, based on the evidence in the record, which was the modeling and the expert testimony provided by the experts about the modeling, that the 8 dB level would be met. So they made a decision on that issue.
And they said that expressly anywhere in this thing? Because that would be great if they actually had written that.
In those 2 pages of the decision which they discuss, we're looking in subpart 4 of their decision discussing the environmental impacts. On those 2 pages, they do, when you look at the use of the word skepticism, it's not skepticism about the entire project.
Right. But if you read the next part of it, they may be able to secure equipment, but then they go on, should the actual noise impacts exceed those presented in the record, especially if violated of the Mass DEP noise policy, the siting board can require additional mitigation. I mean, is that this language we normally get from the siting board?
This is consistent with its past practice, and also consistent with the language of this court in the Andover case.
Is it your understanding, by the way, they can't build this thing unless it's demonstrated? Do you have another look at this? If this doesn't work, is this thing ready to build? I'm just trying to understand. Have you allowed them to build? Meaning the siting board has allowed them to build, and then whatever mitigation is necessary after it's built will be, I'm just trying to understand what rights you have if this doesn't work any.
So they get the equipment built once they have the permit issued and in hand. So the trick here, or
They have the permit now?
yes, the permit,
So they have the permit, they can build this building, and all of this stuff is about mitigation. I'm just trying to understand, have you given the go-ahead to build this, even though you're not sure this is gonna work?
well, this is the first permit, and there's many different steps that, as you know, that they have to weave their way through. So this grants them that permit to start, so they can start to, go out and order equipment and have what they need to have made.
And
Now,
can they start to build the building, this, whatever
Have
this
they
thing
start?
is?
It's not in the record.
Based on what you have permitted right now, can they start construction of this facility?
I think they can move on in the permit granting process.
And what's the permit? Does the DEP have a 10 dB review later in this? I'm just trying to understand, how does the 10 dB get enforced after this?
Well, again, here, with this condition S, this is trying to balance.
Condition S happens after it's built. After it's built, you can require additional mitigation.
There's a pre-construction filing condition, compliance filing that's contained in condition S.
And Justice Wendland asked your opposing counsel about, or your prior counsel about that. What is your understanding of what happens there? Do you have to make another judgment call that it works before they start to build? Or can you delay it until after it's built again?
Well, I think it will depend on what that pre-construction compliance.
So let's say it comes in at 14 dB at Ms. Johnson's house. What happens?
Well, at that point, based on what the siting board does in these types of cases, they will hold a process. So they will ask the project proponent to submit additional information. They will provide notice to the abutter for her to also provide comments and ask for additional process. This is the siting board has, as it did in the Box Pond case, has a process that they follow that's been set forth in the decisions of this court and also the siting board, whereby they will take additional
So
steps.
your position today is that Ms. Johnson would have the ability, standing, and/or be welcome by the board to object to any pre-construction report showing greater than 8 dB?
Yes, and when you look at
And so any pre-construction report showing greater than dB would be a change in the proposed project, right?
I'm sorry?
Or it could be, right? If the company said, I'm not mitigating anymore, 14 dB, just live with it,
right,
right?
Yeah.
And that would require a change, and that would reopen the process.
Yes.
Yes,
What
to
about
the public,
9?
right?
Sorry.
I'm sorry, I didn't hear both
So
questions.
it would open it to the public, right? To Ms. Johnson, abutters, people like that.
If it rises to the level of being a project change, then
Yeah.
yes, there is additional process.
And
that's-
even with regard to the pre-construction build, the board has specified that the company shall communicate with Ms. Johnson about additional noise mitigation measures and attempt to reach consensus. So the board has actually inserted this particular abutter into the conversation regarding to the pre-construction compliance filing.
Yes, Your Honor. And the idea here is that because this first step in the permitting process goes so early and before the equipment is actually built, the board is trying to build in process, and they have with this condition, for the abutter to have the ability to have additional process beyond what would typically exist.
And does the siting board need to do anything? So say it comes in, as Justice Wendland just said, at 14. Does the siting board have to do anything at that point? I understand you're getting some materials, but does the siting board need to issue another decision, or can they just can they build based on the fact that condition S says they're gonna have to mitigate it afterwards?
No, the project proponent is going to have to satisfy the board that they can meet the noise policy standard that what, the 10 decibels or the 8 decibels
Before they start to build.
before they start. They'll be required to take additional mitigation measures and steps. And it built into when you get to the part of the decision where the conditions are contained, right after condition S, there is the very standard language that goes in to the siting board decisions that says that at all times the project proponent has the burden of completely complying with what they've told the siting board that they are going to do. So here, they have made the
That includes results as well as the construction itself. When they say that it's going to have it's going to mitigate to 10, that's part of the project. It's not just that they're going to build it exactly as they did with these specs and these things, but they have to achieve the result as well.
Right. And here, when you look at the board's decision, they do believe that they are going to meet this 8 decibel level. However, just to be completely
Candid?
And provide process to the abutter, they built in this condition with these additional steps to make sure that the 8 decibel level is actually being met, both before construction starts and definitely after construction is completed, and you got the thing cranked up as high as it can go to make sure that that level is met.
I want to make sure that we are talking about 8 dB here, not simply 10 dB, correct?
By 8 dB.
8 dB. Everyone's clear that that's what condition S requires.
That's what the project proponent indicated
Okay.
they could get the equipment to, so that's, at page 2.
And so that's what's required, just to finish your sentence?
Yes.
Okay,
it is.
thank you.
Sorry. And just on page 244, after condition S in the siting board's decision, it says specifically, the findings in this decision are based upon the record in this case. A project proponent has the absolute obligation to construct and operate its facility in conformance with all aspects of the proposal as presented to the siting board.
So it sounds like what you're telling this court is that Ms. Johnson doesn't have anything to worry about.
She is expressly built in, exactly, Your Honor, she's expressly built into condition S, and her concerns will be addressed by the siting board.
Okay. Thank you.
Thank you.